Okay, we're on the record. Court's in session. And good morning, everybody. And the first case we're going to take out of order, and I apologize to everybody, but it's Michael Majoris. Good morning, sir. How are you? Could you state your name on the record?
Yes, Your Honor. Hugo Apollon, Mr. Majoros.
Mr. Majoris, your attorney is there, Mr. Appian.
Mr. Majoris, you're here charged with felony battery. Probable cause has already been found by Judge Tim Bailey, and you're presently being held no bond. And I've been asked to set the bond today. In counsel, I'll hear from you first.
Yes, Your Honor. I'd ask for a bond commensurate with the bond schedule. I think the bond schedule calls for a $1,000 bond. He does have one prior from about 10 years ago. That's his only criminal record. He's a local resident. He's employed locally as well for an electric design company installing security apparatus, Your Honor. So I'd ask for a...
Is he married?
I'm sorry?
Is he married?
Mr. Majoros, no, he's not married.
Any children?
No, Your Honor.
Does he own a home or any property locally?
I'd have to ask Mr. Majoros that question.
Mr. Majoris, do you own any property locally?
I do not, Your Honor.
And where do you live?
I live in Coconut Creek.
With whom?
With my parents.
How long have you lived there?
Quite some time, Your Honor. I'm actually in the process of moving to Deerfield, but it's not said and done yet.
And counsel, I'm asking you this. Skylar Foro, who is that?
It's a person who he knew through acquaintances. They're not intimate friends, but
They're not related?
They're not related, no, Your Honor. They knew friends in common.
There's no reason for any contact?
Of course not. No contact. Your Honor.
State, I'll hear from you.
Your Honor, actually, his prior was an aggravated battery, great bodily harm. That was from 06. This is a felony battery. You got great bodily harm. It's alleged he broke the victim's jaw, Your Honor. We really don't have convenience bonds anymore because each case in this situation is supposed to be taken on a case-by-case basis. I think based on his prior and the level of damage done in this case warrants more than a $1,000 bond. I'd be requesting a $5,000 bond and no victim contact.
Mr. Majoris, what I'm going to do is set a $2,500 bond, but I'm going to order that it go through a surety, okay, so that a surety is involved in this case. I'm also ordering that you do not have any contact with Skylar Foro in any form or manner. Do you understand, sir?
I do, Your Honor.
Okay, if you contact them in any way, that's a violation of your pretrial release. Do you understand?
I understand, Your Honor.
Okay, and you also understand that your bond must be posted through a surety.
I'm not aware of what that means, Your
I'll
Honor.
explain to him.
It's a bondsman, okay?
Okay.
All right.
Okay.
Thank you.
Okay, thank you, Your Honor.
Thank you.
Good morning, how are you? Patricia Henry?
Your Honor, Miss Henry's approaching. She's present.
Good morning, sir. Could you state your name again, please?
Ryan Dessler of the Broward County Public Defender's Office, Your Honor.
How do you say your last name?
Dessler, D-E-S-S-L-E-R.
Dessler. Okay, Mr. Dessler,
Yes.
thank you. Miss Henry, you're here charged with domestic battery. I have reviewed the probable cause affidavit. I find probable cause. And I'm here to set bond. I'll hear from Mr. Dessler.
Your Honor, the incident is allegedly between Miss Henry and her brother and sister. Miss Henry has a boyfriend that lives in Melbourne. She's able to go up to Melbourne and live with the boyfriend. She has transportation between Melbourne and Broward County if she does need to return for any court dates. Miss Henry has lived in Broward County for 5 months. She has a job at 101 Liquors as a store clerk. The only issue, Your Honor, is Miss Henry's belongings are at the residence with the brother and sister who are the alleged victims. I would just ask Your Honor to explain to Miss Henry that she may go one time with law enforcement officers to retrieve her items from the residence.
Does she have any other family locally?
Stating.
Yes, I do.
Who do you have family locally?
Mom, but mom is in cahoots with my other brother and sister, so I do not want her involved.
She lives with your brother and sister?
No, she does not. She lives within 5 minutes.
Okay, well, the reason I was asking as far as being involved is maybe she could go over and get your personal items and get those
She
to you.
could, but I just do not want her involved because she's the main culprit of all of this.
Let's not talk about the
I just
facts.
want to
Let's not,
stay away.
Miss Henry, don't talk about the facts of your case, okay? I would add, Judge,
Mhm.
apparently, according to the probable cause affidavit, the victim did not wish to prosecute.
I read that. I noticed that. State,
I don't want anyone
what
involved.
are you asking
Right.
for?
Your Honor, she was arrested in '07 in Orange County for domestic violence battery, and that was dropped based on that and the allegations, the harm that was done. I'd be requesting a $1,500 bond, no victim contact.
Miss Henry, what kind of bond could your family make?
Excuse me?
What kind of bond could your family post for you?
I have no idea.
Okay. What I will do is I will set a $1,500 bond. I am also going to order that you have no contact with Morrison Baldwin. She is not to return to that address. I am going to permit her to obtain her personal items from the location either through her mother or a family member or through a... Miss Henry, are you having a problem?
I just do not want my mother involved, please.
Well, you didn't let me finish. I was
Okay.
going to say that through your mother or another family member, or you can go there, but you must arrange through a police officer, a law enforcement officer to be there with you. Do you understand?
Yes.
You are not to have any contact in any form or manner with the victims in the case, okay? Thank you.
Okay. Thank you.
Your Honor, I received the request from the jail to call Nigel Rodriguez on page 8 of the docket, if we can call that case out of turn.
Sure. Nigel Rodriguez?
He's approaching, Judge. He's coming in. He was all the way in the back.
Page 8.
And this is the municipal ordinance case, Judge.
Mr. Romero, good morning, sir.
Good morning, Judge.
It's good to see you.
Good to see you, too, Your Honor. He's approaching.
Mr. Romero, I wore the wildest tie that I have today, just in your honor, since it's my last day, but this is as wild as it gets.
And I didn't wear a wild tie. I didn't wear a tie today at all. It's Friday.
Not a problem. Mr. Rodriguez, good morning, sir. You are here
Good morning.
charged with carrying, having an uncovered or open container of alcohol in a public place.
That's correct.
In violation of a city ordinance. A capias has been set in the amount of $100.
All right.
Can you make that bond, sir?
No.
Would you like to resolve that today?
Yes, I would.
Do you swear to tell the truth?
I do.
And is anybody forcing you to do this?
No.
Are you under the influence of any kind of drugs or alcohol today?
No.
Ever been treated for a mental illness?
No.
And you're waiving your right to an attorney and a trial?
Yes, I am.
Do you have any questions regarding any rights you're giving up today?
Not at all.
And are you pleading no contest to one count of possessing an open container of alcohol in violation of municipal ordinance?
No contest.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty, sentence you to time served, and order court costs of $78, and I'll give you 6 months to pay that.
All right, Your Honor. Thank you.
Thank you, sir.
You enjoy your day.
Thank you, I will. Hello? Yeah. Okay. I'm got a call from my JA, and they're asking if we want to start at 1 or 1:30.
We usually, if it's
We
okay with-
usually start at 1 o'clock, Judge.
1 o'clock. Okay. Thank you. Okay, and Yamil Laura? Yamil Laura?
That's North Broward, Your Honor.
North Broward.
Miss Laura, good morning. Miss Laura, you're charged with domestic battery. One count, I've reviewed the probable cause affidavit. I find probable cause. We're here regarding the issue of bond. Ma'am, what kind of bond could you make?
Your Honor, I spoke with Miss Laura. She's been living here in Florida all of her life. She has family here. She has her mother here. She's been living in the same residence for the last 2 years. If released, she could stay with her aunt. I explained to her that she will not be allowed to have any contact with the alleged victim in the case, and she understands that. She's been working in the same job in the medical field for the last 3 years. She's a high school graduate of MacArthur High School. And from what she tells me, Judge, she has no prior record. So I'd be asking the court to consider releasing her on her own recognizance.
State?
She does not have a record, Your Honor. State would be requesting a $1,000 bond, no victim contact.
Miss Laura, do you have family or friends that could post a bond for you?
Yes, I could figure it out, Your Honor.
Do you think that you can make a $1,000 bond? You would have to, you'd have to pay a bondsman $100 for the
Yes.
premium. Okay. All right, so I will post a $1,000 bond. Miss Laura, not post, I am going to set a $1,000 bond. Miss Laura, you cannot have any contact with Dora Woodbury. You cannot go back to that residence until further order of the court. Is there any reason that you need to have contact with that individual?
Well, she lives in my mother's house.
All right.
It's my mother's address.
But you'd be staying with your aunt, isn't that correct?
Yes.
Okay,
Yes.
so, all right, until further order of court, then you can't go back to that residence or have contact. Your mother will have to come see you, okay?
Okay, sir.
Thank you.
Thank you.
Timothy Heislop?
That is main judge.
Mr. Heislip, you're also charged with domestic battery. I've reviewed the probable cause affidavit. I find probable cause, and I will hear the issue regarding setting bond. Mr. Romero?
Judge, this being Mr. Haslett, he's been residing in South Florida for 4 years, but he's been residing in the state of Florida since he was 2 years old. He's 41 years old at this present moment. He is currently employed. He works for GL Staffing. He works in the labor pool. He makes approximately $9.50 an hour. The alleged victim is his fiance. He believes his fiance is basically going to leave the premises. However, what I've advised him is because of this domestic situation, you're going to be imposing a no contact order. He knows not to have any sort of contact. So until he's 100% sure that she's not there, he'll be living separate and apart from her. He'll be actually residing with a friend. Judge, what we'd be asking you to consider is setting a bond approximately $1,000 on this charge, and also asking you to sign an order, a phone order, allowing Mr. Heislop access to his phone contact so he can call someone and post his bond.
Okay, I'm going to grant that motion. State, I'll hear regarding bond.
Thank you, Your Honor. The state is going to be requesting, Your Honor, a $5,000 bond based on the allegations of Mr. Heislop's criminal history. First, he's been sentenced to prison twice in the past. Once out of Escambia County, 2011, domestic violence battery by strangulation. He was sentenced to 2 years and 9 months state prison. 1998, out of Manatee County, aggravated battery with a deadly weapon. He was sentenced to 5 years and 11 months. I'm also showing, Your Honor, he has, I see 1, 2, 3 prior arrests for domestic violence battery that was dropped, and in 1994 out of Manatee County, burglary to a dwelling, criminal mischief, battery, and resisting without violence.
Does Mr. Heislop have any history of not appearing in the outstanding cases?
Do you have his force?
It doesn't come out.
Yeah, Your Honor. Does pretrial have any notes on that? My database that would show that is not is down.
I was just asking.
Yeah, of course.
Okay.
Judge?
Yes, sir.
I've just been informed, Mr. Hyslop, there might be some sort of issue. The reason being is he's going to contact a friend. His friend doesn't have, he doesn't believe his friend has any sort of financial ability to help him post his bond, and therefore, since he does have a valid address, Judge, he's requesting at this time if you could consider standard pretrial.
Where would he be living again?
I would be staying at my address, and my fiance is staying with her sister.
Well, okay, earlier though, that was my
Or
understanding.
vice versa. I mean, whatever is deemed necessary.
Well, Mr. Hyslop, are you sure that she has left the residence? My understanding
I'm not
was,
sure. I'm not sure if she left, but I
let's
mean,
say
if the
that
order
she,
could be,
let's say that she's living there and you get out of jail, where would you go?
I'll go to a hotel. I have access to money when I get out. I just don't have no access to it. I have money in a safe and I can't get to it. And I could go stay at a hotel until she leaves. And I would do that.
Okay, all right, here's what I'm going to do. I'm going to release him to standard pretrial release. He is to report in person once a week. He can return to his residence as long as his fiance is not there. If she is there, he is not to have any contact with her or reside at that residence until such time as she leaves the premises. You'll have to live somewhere else. You're not to have any contact in any form or manner until further order of the court with, I think it's Crow Natasha Lynn. Do you understand, sir?
Yes, sir.
And
Okay, thank you. I'm ROR.
And Your Honor, this ROR to pretrial overstates objection based on his criminal history.
Okay. Okay. Thank you. Claude Daniel?
Mr. Daniels approaching, Judge?
Mr. Daniel, you're also charged with domestic battery. I've reviewed the probable cause affidavit, find probable cause, so I will hear argument regarding bond. Mr. Romero?
Judge, in speaking to Mr. Daniel, he's been residing in our community his whole entire life. He is 27 years old. He's currently employed. He works at a restaurant called Matchbox Restaurant. He's a cook. He's been working for that restaurant now for about 3 months. He's making approximately $13 an hour. Financially, though, he has no money in the bank, no property. He does live with the alleged victim. However, he'll be living separate and apart from the alleged victim. He'll be living with his brother, who resides in Coral Springs. If the state can confirm this is his first arrest ever, he is a registered voter here in Broward County. He would hope his brother or his family could help post his bond, but his brother is on disability, so he's on a fixed income. Considering, Judge, it's a misdemeanor offense, his strong ties to the community's lack of financial resources, I'd be asking you to consider an outright ROR on Mr. Daniel's behalf, if the state can confirm this is his first arrest ever.
Well, he has no record. The state would be requesting $1,000 bond.
I will
Never
set a
contempt.
$1,000 bond and order no contact with Jasmine Mapp in any form or manner. Mr. Daniel, you cannot go back to that residence if she's still living there. Do you understand that? And you are not to have any contact in any form or manner with Jasmine Mapp until further order of the court, okay?
Judge, one additional request. I know your ordered a $1,000 bond, but in speaking to Mr. Daniel, like I said, his brother is on disability. He doesn't think his brother will be able to afford the $1,000. Would you then consider, instead of an outright ROR, would you consider standard pretrial?
Well, it sounds to me as though his family can make the $1,000 bond. It sounds that it's more than his brother locally. Am I correct, sir?
Is there anybody else besides that can help you post your bond, or you're not sure?
I'm not sure. This is my first time going through this experience.
Okay, let me hear from the state. I know, well, you said 1,000, right?
No, and Your Honor, Mr. Romero already presented his ties. There was, I mean, now that the bond is coming out now, he's saying, well, now nobody can. I mean, I think $1,000 bond is reasonable. I think it's manageable.
Daniel, I'm going to leave it at $1,000. If you can't make it, then we'll be seeing you again. Rodney Estelholm?
Your Honor, if we could put places on recall, Mr. Estelholm is being represented by Michael Weinstein. He's on his way.
We're going to put Mr. Estelholm on recall.
Mr. Esselholm on recall? Okay.
We're waiting for his attorney.
Okay.
Janet
Yeah.
Alvarez?
Miss Alvarez, come on up. Oh.
Ms. Alvarez is present, Your Honor.
Thank you. Mr. Alvarez, or Miss Alvarez, I'm sorry. You have a out-of-state hold. The court in that state has set a $10,000 bond. You will be appearing before the extradition judge, Judge Rock Singal. Thank you, ma'am.
Thank you, Your Honor.
Lauren Koshinor?
She's in North Broward, Judge.
Broward, thank you.
Yeah.
Lauren Koshinor at North Broward? Good morning, sir.
North Broward.
Ms. Koshinor, you are being held no bond on a violation of probation. You're scheduled to see the judge on April 25th at 8:30. Do you have any questions, ma'am?
No.
Okay, thank you.
No.
Thank you. Dawn Griffiths?
Also North Broward.
Okay. Ms. Griffiths, you are charged with grand theft auto. It appears to me the probable cause has been already found by Judge Andrew Siegel, and he has set a $1,000 bond. Can you make that, ma'am?
No, I cannot. I had permission to have the vehicle. I don't understand why.
Let's
I'm being
not talk
charged
about the facts, Dawn.
with- Okay.
Judge, she's been living here since 1988. She has family in the area. She has her father. She's been in custody 40 days on this charge already because she was in West Palm Beach and detained there. I've been trying to reach her friend Terry to post her bond. I have not been able to get a hold of him. She has a GED. She has a business doing house cleaning, and she does not really know if she's going to be able to post any kind of bond on this case, Judge. I'm not sure of what her prior record might consist of, but if it's not too bad, I'd be asking the court to consider pretrial release.
Where does she live?
Dawn, where would you be living? You said you can be living with your dad,
Yeah, I'm gonna go with my dad.
and that's in West Palm Beach?
Yeah, that's in West Palm Beach.
Do you know the address?
Yes, 98 Althamy, West Palm Beach, Florida, 33417.
Are you married, ma'am?
I'm divorced.
Do you have any children?
Yes, I do. They live with their father. He has custody.
Where does he live?
He lives in Loxahatchee.
Okay, and how old are the
I
children?
live with my dad. They're 18, 16, 14, and 13.
Okay.
They're grown almost, just about.
Judge, and just so the court's aware, the
It's
reason...
Hold on, Dawn.
The reason she's been in custody is she was originally arrested in Palm Beach on a felony possession of cocaine, and that's when they discovered this warrant. That was dropped. Your Honor, I'm asking that the $1,000 bond be kept in place. She has multiple priors. She's already pled out a battery this year, 2015 burglary of a conveyance and grand theft, 2014 prostitution, 2012 prostitution, 2012 possession of cocaine, 2012 robbery by sudden snatching, 2012 possession of cocaine, 2011 prostitution, 2007 felony possession of a controlled substance, 2010 possession of cocaine, 2008 possession of cocaine.
Ms. Griffiths, are you working? Are you employed?
I have a house cleaning on the side. I have customers in Central Village. Just, I haven't been able to see. So I don't want to lose my customers. I really don't. Yes, I relapsed, but I'm not. I don't want to return to the street. I want to keep my house cleaning business. I'm responsible. I broke up with my boyfriend. That was the battery charge. I did 21 days time served. I did, that was, blown out of proportion, in all honesty. But somebody had to go, so I went instead of him.
Ms. Griffiths?
Okay.
Okay. What I'm going to do is leave the $1,000 bond, but I'm also going to add level 2 pretrial release with a monitor, a GPS monitor. She is to live at
Oh, wow.
that address that she gave in Palm Beach.
If I bond.
As long as we verify, is that sufficient to the court?
It is. Okay, and ma'am, so it's $1,000 bond. If you're released, you're to report to pretrial, okay? Thank you.
All right, I left a
Okay.
message for Terry. I'll try him again.
Sally
All right, thank you.
Rose?
She's also in Pompano, North Broward.
North Broward. Miss Rose, you're charged with robbery. I have reviewed the probable cause affidavit. I find probable cause. I will hear argument setting bond.
Your Honor, Miss-
Aaron?
Your Honor, I'm going to be asking for a $5,000 bond, no victim contact. She had a theft last year, burglary of a conveyance 2014.
I think a $5,000 bond for Miss Rose would be tantamount to no bond. She's lived here all of her life. She has a disability. She has back and neck problems. I'm not exactly sure where she would be living, Miss Rose. Where would you be living?
Unfortunately, I am homeless.
I don't know really what else to say, Judge.
I understand. I reviewed the probable cause affidavit. Ms. Rose, I am going to set a $3,500 bond. And you are not to have any contact if you are released with Mr. David Allen, the alleged victim in this case. Okay? Thank you, ma'am.
Yeah.
Crystal Adams?
Miss Adams is in Maine, Your Honor. She's present and approaching.
Miss Adams, you are charged with giving false information to a law enforcement officer. I have reviewed the probable cause affidavit. I find probable cause. Your bond is set at $100 on that count. You're also being held no bond on 2 separate felonies for violation of probation. You are scheduled to appear before the judge on those cases on 4/25 at 8:45 a.m. Thank you, ma'am.
Your Honor, if I may ask for a photo order for Miss Adams.
Yes, that is granted.
Thank you, Your Honor.
Armani Willis Lawton?
Miss Willis is present and approaching, Your Honor.
Ms. Lawton, you are charged with grand theft. I have reviewed the probable cause affidavit. I find probable cause. Your bond is presently set at $1,000. Okay, thank you, ma'am.
Thank you, Your Honor.
Tony Smith?
She bonded, Your Honor.
Okay. Danielle Longobardi?
That's
Yes.
North Broward, Your
North
Honor.
Broward.
Ms. Longobardi, you are charged also with robbery.
She just arrested.
I have reviewed the probable cause affidavit. Find probable cause. I'll hear argument regarding bond. Mr. Linder?
Your Honor, just to advise the court, and this new offense doesn't violate her conditions since this allegedly occurred in January, but she was arrested April 9th on a DWLS. That's not really that significant. That's still pending. She had a burg dwelling 2007 with possession of alprazolam and theft, and a burglary, conveyance, and grand theft in 06 with a violation of probation. Where she have at North Carolina? Your Honor, out of the state of North Carolina. Yeah. Obtaining controlled substance by fraud. Anything else? Tampering with the vehicle, and that's it. And out of the state of Virginia. Keep showing. Obtaining prescription by fraud. End of record. Your Honor, state would be requesting a $7,500 bond, no victim contact.
Ms. Longobardi, Are you a resident of South Florida?
Judge, she's been living here all of
Yes.
her life, and she believes her father can post a reasonable bond. I don't know about 7,500. I understand what the state is saying. I'd ask the court for a $2,500 bond. I think that that's something her family could do.
Okay.
Yeah, that's a lot
Do you
easier.
think they can do that, Danielle?
Yeah.
2,500?
Yeah.
Where
I
would you be
able-
living? Where would you be living?
With my dad.
All right, I am going to set a $3,000 bond. Ms. Longobardi, I'm also going to order that that bond be posted through a surety. Okay, you're going to have to
Okay.
use a bondsman. And
Okay.
I am ordering that you do not have any contact with the individuals at the CVS store where this, and you're not to go back
Okay.
there, okay? So don't go back there, you're going to be
Okay.
arrested. Okay, thank you.
Okay. Thank you very much.
All right. Mr. Weinstein, can I help you first? Either one.
Oh, go ahead. I have one.
Yes, sir.
Judge Michael Weinstein, I'm here on behalf of Rodney Estelholm.
How do you spell the last name?
It's on page 4.
Oh, the one we have on recall, right here. Thank you. Rodney. I'm sorry, ma'am?
I have a correction to the booking council is booking correct.
Good morning, Rodney. It's Michael Weinstein. I'm here for you. You hear me?
That's better.
So the change is what? Oh, I see.
Oh, so it's even better.
And it's a domestic battery, right? Okay. Okay, Mr. Estelholm, you are charged with aggravated assault with a deadly weapon in count 1, and domestic battery in count 2. Probable cause has been found by Judge Jeffrey Cohen, and so I'm here to set bond. Mr. Weinstein?
Judge, let me be very clear. Mr. Estelholm, this is an ongoing issue with his ex, who it's my understanding is not prosecuting. I can't speak to this ag assault charge. I represent him currently on a Palm Beach matter where bond was just set at $100,000, which he made, and his family posted the bond, and he's on full lockdown in Palm Beach County, so he can't go anywhere.
You mean like on a pretrial?
On pretrial release out of Palm Beach County. So he's entitled to a bond on this case. He only had to see because of the fact that it was a domestic violence charge, set bond. I'm asking because the family just posted $100,000. He's on full lockdown. Just to, I mean, either ROR him with the same special conditions as the pretrial he's already on, or something relatively low.
So you're saying that the ag assault, you're saying there's a bond set in that?
No.
No, okay.
What I'm saying is...
So I have to set bond on both?
You have to set bond regardless. He's entitled to a bond.
Okay. Why do we keep coming to this point?
I don't know.
How do we get there?
These bad prices.
How do we get to this point? We were so good. That's the one that sleep. I put probably upstairs.
Oh, there you go, there you go.
Yeah. Everybody.
That's the answer.
Yeah.
That wasn't supposed to me, so.
Yeah.
And now I'm supposed to go.
Your Honor, I'm going to, based on the allegations and his criminal history, Your Honor, I'm going to be asking for a $10,000 bond on 1, a $5,000 bond on 2. Mr. Estelholm also has a pending possession of firearm by convicted felon in Broward. These allegations predate when he was placed on bond, so this wouldn't violate his release conditions. I want to be clear about that. 2012, out of Broward, fleeing and eluding law enforcement. He was sentenced to 10 years state prison as a habitual offender. 2011, delivery of oxycodone, possession of cocaine with intent. He violated probation, was sentenced to 10 years state prison. 05, possession of firearm by convicted felon. Aggravated fleeing and eluding with the VOP, 10 years state prison. Dealing in stolen property in 04, he violated probation, 10 years state prison.
Judge, if I could just speak to one thing the state said, and that is, he does have an open Broward case, but that is the exact same case as the one from Palm Beach. It's kind of complicated. There's a alleged crime that occurred in Palm Beach, but he got arrested in Broward. So they had to file separately, but that was contemplated when the bond was negotiated in Palm Beach County, number one. Number two, I've already got an offer on the Palm Beach case. They offered him to no cost everything but the firearm by felony and give him 36 months in prison. So he's not even facing anything significant. So I would ask you to take all that into consideration.
What are the charges in Palm Beach?
Right now, he's charged with burglary with a battery, but that's going to be null pros, or at least the offer's been made to null pros. There's
What
more
would
to it than that, but that's the main charge.
And what kind of bond are you asking for on this case?
I would ask for something low because he's already on pretrial in Palm Beach, and he's already on a $100,000 bond.
But you indicated that case is going to be resolved soon.
I've got an offer. I have to meet with Mr. Estelholm to discuss it.
Here's what I'm going to do. I'm going to set a bond of $5,000 on each count. The bond is going to have to be through a surety. I want to post it through a surety. And I'm also going to put him on level 1 pretrial release with a GPS monitor. Patrice, let me ask you, if he is on level 1 pretrial release with the monitor in Palm Beach, and I order it, do we have to duplicate? My concern is. Yeah.
Our pretrial officers are being monitoring.
My concern is that if he resolved that other case and then he's no longer on pretrial release, that's my.
Right.
Yeah, April 25th.
Okay, I am.
Judge, why don't we do this? Why don't you enter an order that the Broward pretrial release is to run, hand in hand with the Palm Beach, but you can't put him on 2 ankle monitors. He's got an ankle monitor in Palm Beach. I just got a order.
Jordan,
I am going to order it, Mr. Weinstein, based on his history. I am concerned about the two.
I don't know how I'm going to get him out. I mean, here's what's going to happen. What's going to happen is you're ordering an ankle monitor. Pretrial's going to come in. They're going to put the monitor on him, and then he's going to have to go back to Palm Beach to get the monitor on. I mean, this just sounds like a logistical. Sorry. Excuse me. Sorry.
No, Mr. Weinstein, I understand it could be inconvenient, but I feel that it is necessary. And that's one of the reasons I'm setting the bond so low as $5,000 and $5,000 because he's out on a $100,000 bond already.
I understand.
But I am going to order level 1 pretrial release with an ankle monitor. Okay, thank you.
Thank you. Sorry? All right, Rodney, did you hear that? You're going to end up having 2 monitors. You're going to end up going back to Palm Beach, getting a monitor there, and you're going to get a monitor here, just so you know.
And Mr. Estelholm, I am ordering that during the pendency of this case and while you are on pretrial release, you are not to have any contact with the alleged victim in this case. Do you understand, sir?
Yes, sir.
Okay, thank you. Thank you, Mr. Weinstein. Counsel, can I have you?
Yes, sir. Good morning, Judge. I'm Jar McLaren. Fort Lauderdale judge. On page 8 of the docket, Your Honor, there's a John Smith. He's in the main jail. He's charged with a trespass, Your Honor.
Mr. Smith, come on up. Your attorney, Mr. McMahon.
I spoke to Mr. Smith this morning, Judge, in the custody, and he was inquiring whether or not the court would be inclined to resolve this matter for him today.
Okay, Mr. Smith, you are charged with a violation of a municipal ordinance of trespass. This is in the city of Fort Lauderdale. Do you understand the charge, sir?
Yes, sir.
And it's my understanding you wish to resolve this today?
Yes, sir.
Do you swear to tell the truth?
Yes.
Is anybody forcing you to do this?
Nope.
Are you under the influence of any kind of drugs or alcohol today?
Nope.
Ever been treated for a mental illness?
No, sir.
And do you understand you're waiving your right to a
I'm
trial?
Oh, in that case too? Okay.
Yes, sir.
Do you have any questions regarding any rights you're giving up today?
Nope.
And are you pleading no contest to one kind of trespass in violation of a Fort Lauderdale municipal ordinance on April 20th, 2017? Are you pleading guilty?
Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty. sentence you to time served, order court costs of $78, and I will give you 6 months to pay that. Thank you, sir.
Thank you. Judge, page 9 of the document is also in the main jail, Your Honor. There's Sean Everin. He's here on municipal ordinance panhandling offense, Judge.
Municipal ordinance and well, they're both municipal ordinances, aren't they? Yes.
Yeah, right, but one of them is not for a bench, Judge.
I can't tell you what. It's a capious.
Right, the second count is a capious,
Right, with a $100 bond.
Yes, Judge.
What would Mr. Everin like to do?
Judge, he would like to resolve this matter.
Both of them?
Yes, Judge.
Okay, Mr. Everin, do you swear to tell the truth?
Yes.
Is anybody forcing you to do this?
No.
Are you under the influence of any kind of drugs or alcohol today?
No, Your Honor.
Do you understand you're waiving your right to a trial?
Yes.
Do you have any questions regarding any rights you're giving up today?
No.
And are you pleading no contest in case number 17002527MO10A to solicitation in a public right-of-way in violation of the City of Fort Lauderdale Municipal Ordinance?
Yes.
And also, are you pleading no contest to standing in the roadway soliciting business on April 20th, 2017 in violation of the city ordinance?
Yes.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty on both counts, order court costs of $78 in each case, and sentence you to time served. And I'm going to give you 6 months to pay those court costs. Thank you, sir.
Judge, last but not least, on page 9 of the docket, also in the main jail, is Stephen Morris. Judge, he's got a little different situation, and I was going to ask if the court would be willing to reset him for this afternoon. The reason is that Mr. Morris has 2 other cases, Judge. They're both for panhandling, as is this one. He had one of them is unfiled. I have the case numbers. The problem that we have in this court, Judge, is that people like he's not up yet, Judge. Mr. Morris, he's sitting right there, Judge. I just want to get him.
Mr. Morris, do you want to come to the podium, sir? Thank you.
The problem is that Mr. Morris he's homeless, Judge. He's indigent. What happens is people in this situation, they'll have these other cases that don't come before the court and magistrates, and at some point a court notice will be issued, will be sent to him. Obviously he won't get it because he's homeless. Then a warrant will be issued, and it takes up time of law enforcement. It takes up time here in the court system. So we try to see if we can resolve all of the outstanding matters at once.
No, I'll be happy to put it to this afternoon at 1 o'clock.
Okay, Judge, and I'll give the clerk the case numbers.
Okay, Mr. Morris, you're going to come back before me at 1 o'clock, okay?
Yes,
Thank
sir.
you, sir.
Thank you, Your Honor.
Who's that there?
Anna Kimbrough?
She's in North Broward. I didn't get a chance.
She's a medical research, Your Honor.
I guess that explains that then.
Thank you. Thank you very much. John Elselmo? Mr. Elselmo, good morning, sir.
Good morning.
It looks like, yes, you're being held on 2 capiouses. Each capious has a $100 bond, and each of them is for basically panhandling in violation of, it looks like a city ordinance. Do you understand that, sir?
Yes, sir.
Can you make that bond, sir?
No, sir.
Your Honor, he would like to resolve his case today if possible.
Do you swear to tell the truth, sir?
Yes, sir.
Is anybody forcing you to resolve the case?
No, sir.
Are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
And do you understand that you're waiving your right to an attorney and to trial?
Yes, sir.
Do you have any questions regarding any rights you're giving up today, sir?
No, sir.
And are you pleading guilty to those 2 charges of panhandling in violation of city ordinance? Are you pleading?
Yes, sir.
Are you pleading guilty, sir?
No contest.
Okay. The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty on both counts, sentence you to time served, order court costs of $78 on each case, and I'm going to give you a year to pay those court costs.
Thank you.
Thank you, sir. Adrian Perez?
He bonded, Your Honor.
All right. Leon Edmonds?
Mr. Edmonds is president approaching, Your Honor. And he declined public defender services.
Okay.
No, I'm not doing that. I'm decline you.
You can tell me for yourself.
Yeah.
Mr. Edmonds, good morning, sir.
How you doing, sir?
Good. Mr. Edmonds, you are here pursuant to a warrant or a capias issued by the judge. The judge set a $500 bond, and the charge is trespass. Do you understand, sir?
Yes, sir.
Can you make that bond?
No, sir. I would like to resolve that today.
State, is this is what I mean is your case.
I would like to resolve
Yeah,
this,
this is a
sir.
state charge, Your Honor.
Do you have any objection to me?
If I could just have one moment, I just want to make sure it's not someone's home.
Okay.
If not, then no, I don't.
Okay. Mr. Edmonds, just give me a moment.
I didn't know that was. I didn't know that.
I just,
Take your time.
yeah, well, I just want to make sure he's not registered. That way, he won't. I don't want him to unknowingly face potential other consequences by taking a plea.
How many children you have?
Your Honor, it wasn't a private residence.
Mr. Edmonds, you swear to tell the truth?
Yes, sir.
What is your full name?
Leon Edmonds.
Mr. Edmonds, it's my understanding you wish to resolve your case today, waive your right to an attorney in the trial. Is that correct?
Yes, sir.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
And are you pleading guilty to one count of trespass other than the structure as charged
Yes, sir.
in case number 17000660MM28?
Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty. Order court costs of $293. I'm going to give you a year to pay that and sentence you to time served.
All right, sir. Thank you kindly.
Hold up, bud. He's president approaching, Your Honor.
Mr. Kern, you're also charged with trespass. Your bond is $25. Can you make that, sir?
Yeah.
No, Mr. Kern wants to resolve his case today, Your Honor.
Do you swear to tell the truth, sir?
Yes, sir.
Is anybody forcing you to do this?
No, Your Honor.
Are you under the influence of any kind of drugs or alcohol today?
No, Your Honor. God bless you, sir.
Thank you. Have you ever been treated for a mental illness?
Quite a few times from Vietnam, sir.
And are you on medication, sir?
No, sir.
The fact that you suffer from this illness, is it preventing you from understanding what we're doing today?
No, sir.
And are you pleading guilty to one count of trespass over at the Broward County Mass Transit bus station?
Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty. Order court costs of $293. I'm going to give him 2 years to pay that. He can make periodic payments. I'm going to sentence him to time served. Mr. Kern, my advice to you, don't go back to that location, okay?
No, sir.
Okay, good luck to you, sir. Thank you.
God bless you, sir.
God bless you too, sir. Jeremy Mack?
Mr. Mack is president approaching, Your Honor.
Mr. Mack, good morning, sir. You are also being held on a $500 bond. pursuant to a capias issued pursuant to you failing to appear. Your bond is presently set at $500, and the charge is petty theft. Okay,
Mr. Mack wants to. Mr. Mack wants to resolve this case, Your Honor.
Okay, Mr. Mack, you understand that there can be some problems regarding your prior record. I don't know what it is, but if I'm going to adjudicate you guilty, and if you have other petty thefts, that could result in the next time in a felony.
And Your Honor, I just want to advise you before you make an offer. In 2013, Mr. Mack was convicted of 2 separate strong-arm robberies. On each, he was sentenced to just over 35 months. On one, he violated probation. On the second one, he was classified as a habitual violent career offender. He's also had felony battery due to priors, violation of domestic violence injunction. So I just want to make sure the court's aware of that.
What do you know? I don't have any information as to
I
how
can get
this
that.
offense occurred.
That's not a problem.
Okay. And I am looking at, it doesn't indicate whether it's a first or second degree misdemeanor.
It's, Your Honor, I believe it's a first because it's with a prior.
Oh,
But
okay.
let me,
Mr.
yes,
Mack,
because,
go ahead.
I'm sorry, because of the, and it mentions in the information he had a prior, so I think that would make it a first degree misdemeanor. Okay, as far as the allegations, Your Honor, this was allegedly at a Publix, November 2016, on East Commercial Boulevard. Allegedly stole $60 worth of property.
Okay, Mr. Mack, do you swear to tell the truth, sir?
Valentine Thomas?
Yes, sir.
You can put your arm down. Please state your full name, if you would.
Jeremy Jamon Mack.
Mr. Mack, it's my understanding you wish to resolve your case today, waive your right to an attorney in the trial in case number 16-00266-1MM28. Is that correct?
Yes, sir.
Is anybody forcing you to do this?
No, sir.
Are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
In the past.
Are you on medication?
No, it wasn't nothing major.
Okay, is it preventing you from understanding what we're doing today?
No, sir.
And in that case, are you pleading no contest to one count of petty theft? In this particular case, it's a first degree.
Yes, sir. Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty, sentence you to time served, order court costs of $293 with 6 months to pay. Thank you, sir. Vincent Panacea?
He's present and approaching, Your Honor.
Mr. Panacea, you're also charged with petty theft, a misdemeanor in the second degree. Your bond is $25. You're also being held in another case pursuant to a capias where the court set a bond of $250. Okay, sir?
Your Honor, Mr. Pancia is interested in potentially resolving this case today.
Well, one of my problems is that I see that what the capias was for was also for a petty theft.
And Your Honor, even though the officer booked it as a second degree, first, it's clearly not it's not his first offense. He has at least 2 prior thefts from what I can see.
Okay, so there's a number of things going on here, Mr. Panacea. You have prior petty thefts, and then you have 2 petty thefts in front of me. What could happen is if you resolve these cases today, next time that you commit one, you could be looking at a felony. Do you understand that?
Do you understand, Judge?
Yes.
Okay, also, I don't know how much time you have, but I am going to sentence you to 15 days in the Broward County Jail with any credit for time served on each of these cases to run concurrent.
Say yes.
Yes, sir.
Okay, do you swear to tell the truth?
I do.
Is anybody forcing you to do this?
No, sir.
And please give us your complete whole name.
Vincent Anthony Panisha.
Okay, Mr. Panicia, are you under the influence of any kind of drugs or alcohol today?
No, sir.
Ever been treated for a mental illness?
No, sir.
And are you waiving your right to an attorney and to trial on both of these cases?
Yes, sir.
And are you pleading guilty to both of these cases, each of them a petty theft?
Yes, sir.
Court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty, sentence you to 15 days in the Broward County Jail in each case to run concurrent with credit for time served, order court costs of $293 in each case. I'm going to give you 2 years to pay those court costs. And I am also going to order, Mr. Panicia, that you do not return to the Home Depot located at the Oakwood Plaza in Hollywood. Don't go back there, okay?
Your
sir.
Honor?
Yes, sir.
We would ask that if you could also issue that same order for the, count 2 is a Home Depot on State Road 7 in West Park.
Okay. You can't also go back to the Home Depot at State Road 7. Okay?
Okay. Yes, sir.
All right. Thank you, sir.
Thank you, Judge.
Thank you.
William Knoll?
Mr. Knowles, President approaching, Your Honor.
Mr. Knoll, good morning, sir.
Good morning.
Good morning, Your Honor.
Mr. Knoll, you're charged with driving while license suspended, and you presently have a $100 bond. I've read the probable cause affidavit. I find probable cause. You're also charged with driving on the sidewalk, which it looks like is a civil infraction. Looking at your DL record, which was run today, April 21st, it appears that your license is suspended. You have a prior conviction in 1999. And also a prior one in 2005. So those are all outside the 5-year period. You're also being held on a capias for $100. And that capias let's see. If I remember correctly, when I looked at this, was for operating without a valid license.
Yes.
Okay, and do you understand the charges, sir? Your total bond is $200.
Yes, sir.
Okay. Thank you.
Your Honor, Mr. Knoll, he's currently undergoing chemotherapy. He has an appointment next week. He has a number of health issues. He's resided in Broward County for 62 years. I've explained to him the ramifications if he does resolve today, and he still wishes to resolve if Your Honor is willing to hear it.
Well, there are no real ramifications as far as his license.
Correct.
His license is still suspended. When was he arrested? I guess yesterday, right?
Yes.
Okay, Mr. Knoll, do you swear to tell the truth?
Yes, sir.
Is anybody forcing you to resolve your case today?
No, sir.
Are you under the influence of any kind of drugs or alcohol?
No drugs today. They gave me treatment yesterday at the hospital.
Okay. When you say treatment, they gave you medication?
Yesterday, yes, they had to take, after they arrested me, they took me to the hospital. They gave me pain meds, antibiotics, because I have an infection up through my bladder, in my urethra tube. And that's why they got to do this chemo, because they're going to take that all out of me.
Okay, is the medication affecting your ability to understand what we're doing?
No, sir.
And are you waiving your right to an attorney and to trial?
Yes, sir.
Okay, and in case number 16, 016790 TC10A, are you pleading no contest to operating a motor vehicle without a valid license, a second-degree misdemeanor?
Yes, sir.
And you're also pleading guilty to driving while license suspended on April 20th, 2017.
Yes, sir.
Okay, the court's going to accept your plea. I'm going to adjudicate you on both counts. I'm going to dismiss the infraction of driving on a sidewalk, I'm going to order court costs on the driving while on both cases of $293. I'm going to give him 2 years to pay those court costs, and I'm going to sentence him to time served on both cases.
Thank you, Your Honor.
Okay. Bruce, do you have a case? You need something? Let me know when you're ready. Joseph Reyes?
Mr. Reyes? Mr. Reyes is here present, Judge?
Mr. Reyes, you are charged with grand theft and uttering a false instrument. Your bond is presently set at $1,000 on each count for a total of $2,000. I've read the probable cause affidavit. Find probable cause. Okay, sir. Thank you.
Judge.
Thank you.
Judge, if we could be heard, my understanding is Mr. Reyes, he had originally, as you can see from the docket, this is addressing counts 3 and 4 he's being magistrated on. He's been in custody now for about over 30 days. And he went ahead and resolved the other cases that were pending yesterday in front of Judge Uson. He was actually placed on felony probation yesterday. So now he's on felony probation, and he's going to have his assigned probation officer. He's going to be assigned, he's going to be supervised. Considering he's going to be supervised by probation judge, and he's been in custody for over 30 days, would you at this time consider, because he's not working, obviously he's been in custody for 30 days, he has no employment, would you consider an ROR on counts 3 and 4, considering he's going to be supervised? And if he messes up, it's going to be a violation of probation.
All right. First off, he hasn't been in custody over 30 days. He was arrested March 31st. Secondly, he's being supervised on a separate case.
Only 30 days.
Not this case.
Sorry,
he's being supervised probation on a separate case, not this case. Considering that what he's on probation for is grand theft, that he was also out on he was out on a petty theft when he got originally arrested, and he had his bondsman didn't have enough confidence to repost his bond. He surrendered his bond. I think it's reasonable. The convenience bonds are reasonable.
I'm just a little confused. I thought that there was accounts 1 and 2.
Yes, and
he resolved those cases and were placed on probation. These counts 3 and 4 stem from that same case.
No. While he was in custody, this allegedly occurred February 17th. Law enforcement investigated it. At a certain point, they determined that he was committed these offenses and charged him.
These were committed at a different time.
Completely separate from 1 and 2, Judge.
Let me ask you, Mr. Romero, you said that there would be ramifications if he didn't show up.
Correct. What happens if he doesn't show up to court? Obviously, that's going to be a violation of probation. His probation officer is going to submit a warrant for Judge Uson to sign, and then he'll be back here on a no bond hold. So basically, if he doesn't come to any of his future court dates, if he doesn't report to his probation officer, all those would be technicals. So therefore, there is an assurance to the court that he will appear before for future court dates, and that's what we're here for, to make sure that he appears for his court date.
I could be wrong. I could be wrong, but I don't think it's a condition of his probation for him to appear on these cases, because I don't remember it. As I remember the orders that I read, it's not contained in the order, and I'm sure Judge Uson didn't indicate it orally that that's a condition of his probation.
And Judge,
so I don't think it would be a violation. That's my concern.
And Judge, aside from that, if he didn't show up, he'd be held to a bond in these cases. That in and of itself doesn't mean an ROR is appropriate, just because there's ramifications if he doesn't show up in court.
What do you advise?
I'm just asking the convenience bonds to be kept in place. I think it's reasonable, considering that what he's on probation for is a grand theft. He pled out another petty theft, and we're here on another allegation of theft.
Mr. Romero, I'm going to leave the bonds as set at $1,000 on each count. Thank you.
Yes, sir.
Okay. Now, the next person is LaShawn Spriggs. Didn't we hear him yesterday?
Your Honor, these are actually ad charges. They ad charges that were added since the hearing yesterday. These are new allegations that they've tied to Mr. Spriggs at law enforcement.
If I remember correctly, and Mr. Spriggs, good morning, sir.
Good morning.
Are the ad charges on the second page?
They should just be, well, I don't know what's in front of you, Your Honor, but on the booking sheet, counts 20 to 23 are the ad charges that are before the court today.
20 through 23?
Yes, Judge.
Got it, okay. And if I remember, I revoked his...
You revoked, that's why we're up to these counts.
20 through 23. Mr. Spriggs,
Did we do counts 1 and 3 yesterday?
Yes, we
'Cause
did.
the docket shows that there's a hearing scheduled for those, but I thought we took care of those yesterday.
We did.
Yeah,
And the others are out-of-court holds and court orders with no bond. And now he's just being, its first appearance on 20 through 23. Mr. Spriggs, you're being charged in count 20, possession of burglary tools, count 21, burglary of an unoccupied conveyance, 22 is grand theft, and 23 is burglary of an unoccupied conveyance. I had not read the PC. Give me 1 second, because I didn't realize it was an ad charge, even though it's stamped in red right in front of my face. Okay, I've read the probable cause. I find that there is probable cause regarding these cases.
And Judge, I was just going to be requesting the same, on the burglaries, I was going to be requesting the same $20,000 bond you set yesterday on his burglaries.
Okay, Mr. Romero, do you want to be heard, or Mr. Reedy?
No, Judge.
He's being held no bond. Financially, he can't post any bond, so I just asked for a $1,000 bond on each count.
Okay, what I'm going to do is set a $20,000 bond on each of the 2 burglaries, a $5,000 bond on the grand theft, and a $5,000 bond on count 20, the possession of burglary tools. Thank you, Mr. Spriggs. Desmond Lewis?
Mr. Lewis is approaching, Judge. He's declined the service of public defender.
Mr. Lewis, good morning, sir. You're being charged with domestic battery by strangulation. I have reviewed the probable cause affidavit. I find probable cause. And I am set to hear argument on setting bond. Mr. Linder?
Your Honor, unfortunately, Mr. Lewis isn't on my list. Does pretrial have any notes if he has a criminal history? Okay.
Okay.
Your Honor, just based on the allegations in the report, the state would be requesting a $5,000 bond, no victim contact.
Okay, and Mr. Romero? I thought that
Judge,
he didn't
Mr.
want
Lewis
the
is
services. Does he want the services of the public defender?
Well, I think he changed his mind now. He's going to apply for a public defender, Judge. I think he did. So could I have 30 seconds to inquire?
Sure.
Thank you. Judge, thank you very much. Judge, in speaking right now with Mr. Lewis, he's been residing in South Florida for 14 years. He told me he is employed. He works for a company called Trevidia Health. He makes approximately $15 an hour. He advised me that he can't go and reside anywhere else. Judge, when I asked him who he can contact to help post his bond, he says he has no one he can contact to help post his bond.
Okay, Mr. Lewis, I can't release you and let you go back to that residence where your wife lives. I can't do that. Do you have any place else?
Well,
do you have any place
Your
else?
Honor, The reason I can't afford to live anywhere else because I pay all the bills in the house. My wife's not working.
Well, I understand that. It puts us in kind of a dilemma here. Is she still living there?
Well, yeah, she is. Officially, yes.
I don't know what to say, sir. Are you gonna hire?
Well, I don't. When you say officially, I'm not quite sure what you mean by that. Is she
My
living
wife's
there
in
or
and
is she
out.
not?
She comes and goes. She stays by friends a lot.
Well, can she stay with a friend and let you live
Yeah,
there?
she can. Yes, she can.
Is she willing to do that?
I do not know.
Yeah, I mean, Your Honor, that's the type of thing where if the defense gets more information at a later date, they can certainly seek to modify with more information, more information for the court. But certainly we can't, go based on his word when she's not here.
No, I'm not. I'm
No,
not.
I know. I know you're not.
No, he can't talk. I think like the other day, I can place him on pretrial release with the condition that he does not have contact or live there with his wife.
He can only talk to me if he's actually my supervisor. No, you.
You're gonna send no contact, then you can't call
No, just standard.
Every week we have a different judge.
Reporting, once a week to determine where he's living.
Got a really terrible one next week.
Mr. Lewis, you don't have any family in the immediate area?
No, sir, I don't. All my family's in California.
Do you have any friends?
No, I can stay with. They all have their own families.
Okay, well, I'm willing to put you on standard pretrial release. You're going to need to report once a week in person to pretrial. I'm going to order that you do not have any contact in any form or manner with Evelyn Arm. You are to stay at least 500 feet away from her. And the thing is, though, that if I'm going to ROR you, but if you are released, you have to report to pretrial release, and they're going to verify that she's not living there.
He was the first time he met with me.
I'm sorry.
Uber was supposed to talk to him. It's just I don't.
Well, how do we know that he can go back to that residence? Oh, no, I'm not. Right, no, I understand. I'm not going to tell her to leave. But if she's not there, then he can go back. If she is there, she can't go back.
The problem, the problem with that is, Judge, is if they can't reach her, what if let's say hypothetically she leaves the house for a day and he just says, oh, she's not there, so I'm going in. Now she's effectively doesn't have a home.
Mr. Lewis, we're trying to solve this dilemma here. I'm willing to release you on your own recognizance on pretrial release, but if you go back to that residence and your wife is there, you can't go in, you can't have any contact with her. You're going to have to find somewhere else to stay.
Okay.
Do you understand that?
Yes, I do.
Okay, now, hold on. Now, if you go back there and she's there and pretrial release finds out, that's a violation of your release and you're going to be back in here. Do you understand that?
I do.
Okay, Mr. Linder, do you
Well, Your Honor, first off, the state would be objecting to his release on non-monetary conditions. And my concern with the way the no contact order is being worded is, let's say hypothetically, she's out running errands for the afternoon. He comes home, she's not there. Under your order, she's not there, so he can go in. And now we have an alleged victim that finds herself in a situation where she comes home. Either I have to go into my home where he is, the person who allegedly just strangled me, or...
That's not how the order reads. Mr. Lewis, let me make it clear to you, okay? that if you go there and she's not there, but then she comes back home, you have to leave. Do you
I have to leave.
Yeah, okay.
Okay, I just want.
Okay. Okay. Thank you, sir. Thank you. Mr. Radikoff, can we help?
That's your attorney, Mr.
Yes,
Radikoff.
good morning, Judge. Bruce Radikoff on behalf of Geraldo Garcia.
Geraldo Garcia? Mr. Radikoff, sir, your attorney.
Good morning.
Good morning.
I'm looking.
Here it is. Okay. Mr. Garcia, good morning, sir. Mr. Radikoff,
Morning.
your attorney, is present. You are
yes.
presently charged with trafficking in, wow, MDMA, actually. I'm just
Yes.
going to shorten it,
Yes.
okay?
Yes. Yeah.
Trafficking in LSD, 7 grams or more, possession of oxycodone, possession of amphetamine, and possession of cannabis over 20 grams. I do find probable cause, after having read the probable cause affidavit, and your bond is presently
$327,000.
how much?
$327,000.
$327,000. Okay, sir?
Judge,
Yes, correct.
I understand we're at a first appearance hearing. However, I have known his partner for a number of years. Received a phone call last night that this arrest had occurred. I want the court to know at this point that Mr. Garcia completely cooperated with the police pursuant to the probable cause affidavit, gave a full statement, cooperated, told where he got it from. The amount of the drugs that he said he paid for was 312 pills, which was 148 grams, was $250 off of a website. Mr. Garcia has been a 10-year resident of Florida. He is a United States citizen, a lifelong resident of the United States. He works as a project manager at a condo. He's I don't want to say handyman, but he's been there for the last 3 years. He's held the same job. He's lived in the same home, which he went to with his partner for 3 years. He has no prior record. I believe this is his first arrest ever. He does have family, but not down here. His mother and 6 brothers all live in New York City. He's never failed to appear at a court hearings where his appearance was required. Judge, and I know you know as well as everybody, the purpose of bond is to protect the community, to ensure his presence at trial and protect the integrity of the courts. I think a $327,000 bond for what amounts to $250 worth of pills. The big bond is on the LSD, which was found not in the packages received, but was found in the home. I had not been through the statute that far back into it. I was very surprised to see that possession of 7 grams or more of LSD carries a 15-year mandatory and a $500,000 fine. I think he's a candidate for bond. I think the court could fashion a bond whereby you can ensure that he will be back in court, whether that be by a lower financial obligation and a monitor, pre-trial release in a combination. I'd ask the court to consider reducing the bonds down to a total, and this is based on the amount of drugs, the value of the drugs they found, which the court is entitled to consider as well. I'd ask the court to set the bonds in the amount of no more than $50,000. He's not a 50. He's not a wealthy man. He does not, he has bank accounts as well in here. He's stable. This is obviously going to be a case, the probable cause holds true, of some type of substantial.
Let me ask you just a couple questions. Is he married?
He has a domestic partner. Yes.
Okay. No children?
No children.
And does he own any property?
He does
in
not
Broward
own
County?
any real estate in Broward County.
Okay. Does he have any family here?
He does own an automobile. I'm sorry. He has an automobile.
Okay, but no real estate?
No real estate. His family is all in New York City.
You said that. And does he have a passport?
Yes, he does, which he's willing to surrender.
Where is he from? New York?
Yes.
And I'm really asking both of you to educate me on this. The trafficking in MDMA, is that a mandatory minimum?
Yes.
What is that? The mandatory? 3?
It's a 3, and the LSD is a 15-year mandatory.
15?
15.
The others don't have mandatories, if I remember
No,
correctly.
just
They're
trafficking.
third-degree felonies,
Right.
right? Okay. And State, I'll hear from you.
Thank you, Judge. Your Honor, the state's going to be requesting that the convenience bonds be kept in place. I think based on the information that the court has and what's provided in the probable cause affidavit, a more thorough bond hearing would be required to really set appropriate release conditions. It is true Mr. Garcia has no record, but that's really not as great a mitigating factor in this particular case, considering, as we've already stated, if convicted, he faces a minimum mandatory prison sentence. I think then the court has to take in consideration the strength of the evidence based on what's before the court at this time, and it appears to be very strong evidence against Mr. Garcia on these charges. Additionally, Your Honor, I would note, based on as far as his financial ability, based on Mr. Garcia's own admissions, he's been selling pills. He's been selling pills for how long? I don't know. The amount that he paid for the pills, I don't know if that is as relevant, because for all I know, he might have gotten a great deal, and the profit he could have made on selling these 300 some odd pills and pills he's been in the past could be a substantial profit. And lastly, Your Honor, I think there has to be an inherent concern about risk of flight for anyone that's facing a possible 15-year minimum mandatory sentence.
Okay, here's what I'm going to do. I'm going to lower the bond on count 1, the trafficking in MDMA, to $20,000. I'm going to lower the bond on trafficking in LSD to $50,000. I'm going to set bonds of $1,000 in each of the 3 felonies. I am also going to order that upon release, he is to be supervised by pretrial release. I'm going to set it at level 2 with a monitor that will allow him to work. Otherwise, he is to remain at home. But I'm also on that order. I'm not just delineating employment. He can, whatever's on that second paragraph, that paragraph on level 2, I'm permitting that. Okay. All right. Thank you.
Well, Your Honor, the only thing I would request is, I believe, counsel, you say he has a passport, or I would just ask for a passport.
Sure, surrender the passport.
I am ordering that he surrender the passport.
And I would just ask that it be surrendered to the clerk's office prior to his release, Your Honor. Prior to his release.
Can you do
I
that?
have no problem with that, Judge.
Okay.
I'll have it brought down today.
Okay.
Yeah.
So his passport has to be surrendered to the clerk prior to his release. Thank you, everybody.
Judge, thank you very much.
Okay.
I'll bring it to order. Just hang on for a minute.
Okay, take care. Clifford Aline?
Mr. Aline's here present, Judge. He declined to serve as public defender.
Okay, Mr. Aline, you are presently being charged by pursuant to 2 warrants. So probable cause has already been found. One is failing to remain at an accident scene. Your bond is $100. And the other is possession of cannabis. Less than 20 grams, which I don't understand. That's a felony. Why is that?
One moment, Judge.
Oh, I see. It's under. No, it's
a misdemeanor. Your Honor, these are filed charges, so it has a felony case number, but there's just a misdemeanor charge attached.
Okay. And your bond is $100 there, so your bond is a total of $200 on those 2 counts. Do you understand, sir?
Yes, sir.
And I do. Well, probable cause has already been found. Thank you, sir. I'm sorry. It's $100. It was set in a case. Alan Bell.
That'll be main jail.
Main jail, Mr. Alan Bell. He's approaching, Judge.
All right. Mr. Bell, you're charged with possession of cannabis less than 20 grams. Your bond is set at $100. You're also being held on 2 violations of probation on 2 separate felony cases, and you're being held no bond. You are scheduled to appear before the division judge on May 1st at 8:45. Thank you. Hugo Marquez.
Mr. Marquez, come on up, please.
Mr. Marquez, you are being held no bond on a violation of probation. You are also being held on a capias issued by the court setting a $500 bond. You're scheduled to appear before the division judge on 4/25 at 9 a.m. Thank you. Thank you. Christopher Pierre. Mr. Pierre, you're being held on 2 violations of community control on 2 separate felony cases. You're being held no bond, as I said, and you're scheduled to appear before the division judge on 4/25 at 8:30 a.m. Thank you.
Matthew Siegel, come on up.
And Mr. Siegel, you're also being held no bond on a violation of probation. You're scheduled to appear before the judge on 4/25 at 8:30. Thank you.
Yes, sir. Thank you. Michael Maharos?
Jason Wingold, isn't it?
Jason Wingold? Oh, okay.
Okay.
Okay, we did him.
First case on the
Mr. Wingold? Mr. Wingold, you're being held no bond on a violation of probation. You are scheduled to appear before the division judge on April 25th at 9:45 a.m. Thank you. Carrie Isaac.
Mr. Isaac, come on up.
Mr. Isaac, you are being held pursuant to a robbery. I've read the probable cause affidavit. I find probable cause. I believe that this is the same case as the...
He's the co-defendant.
Yes, Your Honor, with Sally Rose.
Mr. Isaac, I see that you're homeless. Is that correct, sir? Okay, and we're here to set bond. Mr. Romero?
Judge, as you heard, Mr. Isaac is homeless. He's been residing here for 20 years. No money in the bank, no property. He's not working. There's nobody that he can contact to post his bond. The last time he was employed was when he was dealing in construction, and he would make approximately $14 an hour. That was last year. So at this time, he's financially indigent, Judge.
Your Honor, it would appear Mr. Isaac is out on a felony theft, possession of cocaine. His ROR charges have not yet been filed, and his arrest was in late February of this year. He has a felony petty theft from last year, possession of marijuana 2013, 2002. Your Honor, based on his criminal history, the state is going to be requesting a $7,500 bond. Also noting that based on the allegations, his involvement was more violent than his co-defendants.
All right, Mr. Allen, what I'm going to do is set a $5,000 bond. Also, I'm going to order that you have, I'm sorry, Mr. Isaac, I'm setting the $5,000 bond. Also ordering no contact with Mr. David Allen in any form or manner. Thank you, sir. James Meadows?
North Broward, Judge.
Mr. Meadows, good morning, sir.
Morning, how are you?
Good. You... Yes.
It should only be booked one time in the case number.
Should have also been at the beginning of the document.
Okay. Mr. Meadows, you're being held on one out-of-state hold. You're being held no bond. And
Correct.
I'm just trying to find the case number. Are you talking about the warrant number?
Yes, the number it should be is E as in Edward 324312.
All right, so just for the record, the warrant number is E324312. The one on the order is incorrect. Do you have any questions, sir? You'll be seeing the extradition judge, okay?
Well, I do have a question. Do you have my charges in front of you?
Did I see that? You mean, what is the charge on the out-of-state hold?
Yeah, the last one. I don't understand what that is.
Looks like armed robbery, sir.
What's the CON stand for?
The what?
The CON on the fifth one?
I don't know what you're talking about.
Count 5 on the docket indicates an out-of-state hold for a armed robbery.
My guess is conspiracy.
Yeah, that could very well be. But that's not really what he's being held on. That's an error anyway, right? Isn't it just
It's
one armed
case of-
robbery?
Well, it's one case, multiple charges. But the point is, when he has his extradition hearing, the judge will go over in more detail what the.
Thank you,
warrant
sir.
is.
All right, thank
you. Jordan Isaacs?
I've been informed Mr. Isaacs bonded, Judge.
Okay, Mr. Isaacs is bonded.
16.
Jonathan Mayo?
I've been advised Mr. Mayo is a medical reset.
Okay, that'll be, I guess, what, tomorrow?
Correct.
Donald Streeter?
Mr. Streeter is a Pompano judge. I understand he does not care to join us this morning.
Okay, is that correct, North Broward?
Yes, Your Honor, it is. He's not medically reset. He just flat out said, "I'm not going." So
Okay.
it's up to you. We can get him here. It'll take 4 or 5 of us to bring him.
Well,
or we could just do however you want.
He's being held no bond anyway, so we can reset this for a week.
Okay.
Thank you. Good enough. Malcolm Robbins?
Mr. Robbins is here, Judge. He declined the services of a public defender. He thinks his family is going to hire an attorney.
Okay. Mr. Robbins, has your family hired an attorney?
Yes, they said they were going to hire one, hire an attorney or post my bond today.
Okay, well, if you would like me to, what I can do is reset your case tomorrow morning in an abundance of caution, and your attorney can be here. If they post the bond,
they should post my bond.
If they post the bond, then that's fine.
Okay.
You want me to do that?
Yes. No, they'll post the bond.
No, I understand that, but I'm just in an abundance of caution going to reset it for tomorrow morning, so that if you are not bonded out, you can notify your attorney and your attorney can be here.
No, I'd rather them post the bond.
I don't think that you're understanding what I'm saying. If bond is posted, you'll be released today. Do you understand that?
Okay.
And then tomorrow they'll just say to the judge, the bond's been posted, and that'll be the end of it. But if you're not bonded out, at least you'll be in front of the first appearance judge with your attorney. Do you understand that?
Yes, sir.
Okay, that's
Yes,
what
sir.
we'll do. Thank you, sir.
All right. Thank you.
Jason? Okay, Mr. Radikoff. Good to see you.
Good to see you.
Take care. Jason Vandenberg?
Good morning, Your Honor.
Good morning, sir.
Your Honor, oh, sorry, go ahead, sir. I apologize.
You're being charged with resisting or obstructing without violence, a first-degree misdemeanor. Your bond is presently set at $100, and I find probable cause, having reviewed the probable cause affidavit.
I would like to resolve them cases, Your Honor, please.
Well, before you say that and before you do that, you have a violation of parole and you're being held no bond anyways.
No, that's correct. That's okay, Your Honor. That's all right. On the parole board, that's CRD. I have to go back to DOC, Department of Corrections, for 108 days for failure to appear to the parole board.
Okay, but I can't tell you what effect the fact that you're pleading to this resisting or obstructing without violence, which is a first-degree misdemeanor. I can't guarantee you or promise you what effect that's going to have on the parole board.
It's not going to have any effect whatsoever, Your Honor.
Okay, well, you know better than I do.
Actually, you're the judge.
No, I'm not being facetious.
No, I got you. Okay. I got you, yes, sir.
The resisting and the municipal ordinance is...
it's an open container.
Yeah. Open container. Okay, with the city of Fort Lauderdale. Okay. Sir, do you swear to tell the truth?
Yes, sir, I do, sir.
Is anybody forcing you to do this?
No, sir, not absolutely not.
And what is your full name?
Jason Lee Vandenberg.
Mr. Vandenberg, it's my understanding you wish to resolve this case, waive your right to both to an attorney and a trial. Is that correct?
Yes, sir. That is correct, sir.
Do you have any questions regarding any rights you're giving up today?
No, sir, I do not, Judge Hurley.
I'm Judge Pohl. Judge Hurley's no
Oh,
longer.
Judge Coles, I apologize
That's
sincerely.
all right. Not a problem. Have you ever been treated for a mental illness?
No, sir.
And are you pleading no contest to one count of resisting arrest without violence and one count of an open container violation with the city of Fort Lauderdale?
Yes, sir.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty on both, sentence you to time served on both, order court costs of $293 on count 1. I'm going to give you 2 years to pay that, and $78 on count 2. I'll give you 2 years to pay that. Do you have any questions, sir?
No, sir, I do not.
Good luck to you.
Thank you. Now I can go back to you.
Christopher Guillaume?
Mr. Guillaume's approaching judge. His family's going to post his bond.
Okay. Mr. Guillaume, you're being charged with possession of cannabis over 20 grams. It's a felony. Your bond is presently set at $1,000. I do find probable cause, having read the probable cause affidavit. Thank you. Ryan Bergeron?
Mr. Ryan, I've been advised he bonded, Judge.
Oh, okay. Thank you.
Okay.
Charles Gaskin.
Mr. Gaskin, you are being charged with a violation of a municipal ordinance, and let's figure out what that is.
It says open container here,
It's an
Judge.
open container with of alcohol violation. Your bond is set at $25. You're also being held no bond on a violation of probation. You're scheduled to see the judge on April 25th at 8:30. Thank you, sir.
Judge, and Mr. Gaskin, I believe he advised me he was arrested in Fort Lauderdale. If on count 1, if the municipal ordinance stems out of Fort Lauderdale, would you, I know on the VOP he's going to be held no bond. I believe he's financially indigent. I don't know if Your Honor would be appointing Mr. McLawrence on count 1.
Not at this time. I'm going to let him appear before the division judge. It may not be necessary.
Yes, Judge.
Okay, thank you. Aaron Chin?
Mr. Chin, come on up.
Mr. Chin, you are being charged with uttering a false instrument, 2 counts of grand theft, and 1 count of possession of cannabis less than 20 grams. I have reviewed the probable cause affidavit. I find probable cause. Your bond is presently a total of $4,100.
Judge, would you sign an order allowing him to have access to his phone to call someone to place his bond?
I would.
Thank you.
Thank you,
Your Honor.
Kenson Narcisse?
Mr. Narcisse?
Mr. Narcisse, good morning, sir. You're being held no bond on a violation of probation. You're scheduled to appear before the division judge on April 26th at 8:30. Thank you, sir.
Devontae Thomas?
Mr. Thomas, you're being held on a violation of probation with a bond set by the judge at $4,500. You're also charged with false information to a law enforcement officer. I find probable cause, having read the probable cause affidavit. Your bond is set at $100 on that. And you're also being held no bond on a violation of probation. You're scheduled to appear before the division judge on 4/25 at 8:30. Okay, sir? Thank you.
Larry Thomas?
Good morning, Mr. Thomas. You're being held no bond on a violation of probation. You're scheduled to appear before the division judge on April 26th at 8:45 a.m. Thank you. David Beckboat?
I've been advised Mr. Backboat bonded, Judge.
Okay, thank you. Leonore Metellus?
He's present and approaching, Your Honor.
Mr. Metellus, good morning, sir. You're being charged with grand theft. Your bond is presently set at $1,000. And I do find probable cause, having read the probable cause affidavit, and I see there's a gentleman.
This is his father, Judge.
I see that there's a gentleman here, sir, and what is your name? Take a moment, you're all right.
So we believe that he would be a good candidate.
Standard?
Standard, yeah.
And how often is he to report?
Twice a week.
By phone? Okay.
The state has no objection.
Okay, Mr. Metellus, I am going to ROR you on this and release you into the custody of pretrial release, standard pretrial release. You are to report to pretrial release twice a week by phone and once a month in person. Do you understand, sir?
Yes, sir.
Twice a week by phone, once a month in person. And upon release here, he is to report to pretrial release, okay? Thank you.
Right now, today?
And, Your Honor, just,
If he wants to sit and wait for court is over, I can talk to him and give him a knock if he has time.
Yes, I can.
You take a seat. When court is over, we'll talk.
We're almost done.
And Your Honor, because I don't know the circumstances and abundance of caution, I would just ask that the court could order, could you, wait, could you please have him come back, please? Could you court order no contact with Armani Willis Lawton? That was the owner of the checking account that...
Okay. Is he still there?
I just saw him walking in the back.
Gerard Clifton? Yeah.
No,
Present,
no,
Your Honor. Oh, sorry.
We need Mr. Medalist back.
Oh, sorry. He already walked out, Your Honor.
How far have you gotten?
Mr. Metellus! Metellus!
Could I see that? Do you still have it? It's Wells Fargo Bank.
Well, that's where it occurred. I mean, Your Honor...
Mr.
The thing is,
Your Honor.
the thing is,
No contact
with the
And we're not having.
Armani Willis Lawton, who's the owner of the checking account.
Okay. Mr. Metellus, also I'm ordering as a condition of your release that you are not to have any contact in any form or manner with Armani Willis Lawton of Wells Fargo Bank. Do you understand, sir?
Yes.
Okay, thank you.
Wait. Your Honor, can you wait there one moment? I just want to make sure I'm not reading this incorrectly.
Hold on,
I'm sorry.
Mr. Medalist.
Mr. Medalist, come on up, please. I think Mr. Leonard forgot something again. Come on.
Yeah. Well, I could repeat myself 5 times over, then I'd never forget anything.
Who else do you want me to order?
No, it wasn't someone else. I wanted to make sure I'm reading this correct. I don't want you to give you someone who there shouldn't be a no contact order with.
Well, I'm just going to tell him not to go back to the Wells Fargo
That's
Bank.
fine.
Okay, sir, don't go back to that Wells Fargo Bank, okay?
All right.
Okay,
All
thank
right.
you, sir.
Thank
Now-
you.
Now
Thank
you
you.
can really go.
All right. Thank you, sir.
Sherrod Clifton?
Sure.
Mr. Clifton, you're being held no bond on 2 separate felony cases for a violation of probation. You're scheduled to see the judge on May 1st at 8:45. Thank you, sir. Yasar Ali? Mr. Ali, you're being held pursuant to a charge of selling single cigarettes as opposed to in a pack. Your bond is set at $100. I've read the probable cause affidavit, find probable cause. You're also being held no bond on a violation of probation. You're scheduled to appear before that judge on 4/25 at 9 a.m. Do you understand, sir?
I understand, but for single cigarettes, can you violate the
Don't.
I don't even know how that's a crime, really.
Thank you.
I think it's a state statute. Yeah. Cadet Alexander? Mr.
Alexander here, present.
You are being charged with robbery, and isn't this the one with the, no, this is, okay, with the CVS?
Yeah, we had his co-defendant earlier
Right,
also.
I remember that. Mr. Alexander, I find probable cause, having reviewed the probable cause affidavit, we're here to set bond. And, Mr. Romero, I'll hear from you, sir.
Judge, just to refresh my recollection, do you know what was the co-defendant's bond amount?
I do not. I remember
Mr.
setting
Reedy,
it.
do you remember?
Yeah, hang on one second.
Mr. Romero, just let me ask you, what difference would that make?
No, it's just for my own edification.
No problem.
It was 3,000.
$3,000.
Judge, what I'm going to be requesting, Judge, is a $2,000 bond. Here's the reason why. Mr. Alexander has been residing in South Florida his whole life. He is 34 years old. At this point, he's unemployed. He's currently looking for work. He was previously employed doing pressure cleaning, making about $10 an hour. He has no money in the bank, no property. He lives in Oakland Park with his mother, been residing at the same apartment for 6 years. His mom works at the swap shop making minimum wage, so he thinks that maybe she could have access to about $200, so hopefully with the bondsman, that'd be 10%. So that's why we'd be asking for $2,000, Judge.
Your Honor.
If I'm reading this correctly, I just want to make sure I understand the facts. The facts are that the allegations are that he was like a co-conspirator and that he was the getaway driver.
But Judge, I don't know. I mean, it seems as though Miss Lombardi committed a crime of opportunity while inside the store. The cash drawer popped open and then she reached in and grabbed three $20 bills. I don't know that there can be a connection made there between Mr. Alexander's knowledge of what Miss Lombardi was going to do. It appears she was going to go in and try and return an item that was fraudulently obtained or something along those lines.
What you're saying is that you don't feel that there is probable cause?
I don't think there's probable cause to tie Mr. Alexander into that robbery as a co-conspirator.
Let me hear from the state.
And that's why I think the fact that where it mentions that they have a history going to CVS stores, making fraudulent returns of items stolen from CVS stores, I think that's relevant for probable cause purposes.
So do I.
But that's not robbery.
Well, any acts of the co-conspirator are to the...
But if the conspiracy is to fraudulently return an item, and it would seem, and I agree with Mr. Linder 100%, that's maybe what they were doing. They are not robbing anyone. They are defrauding CVS. The conspiracy is to defraud. The robbery is an independent act of Miss Lombardi, separate and apart from whatever conspiracy the state thinks they can establish between Mr. Alexander and Miss Lombardi.
That's an affirmative defense, and I understand that. The question is there probable cause? I am going to find probable cause. State, please.
Your Honor, I would say I think his bond should probably be higher than his could have been. It's based on his prior record. He's got, when I count, 8 prior failures to appear in court. He's had, one moment, Your Honor. He's had a, let's see.
Mr. Alexander, are you working? You're looking for work. I remember that now. Okay.
And while Mr. Linder is looking, Judge,
where does he live?
Oh, he's still looking? He's still looking? Okay.
No, Mr. Romero, where does he live?
Yeah.
Where does he live?
He lives with his mother. He lives in an apartment in Oakland Park. We've been residing at the same address for the past 6 years.
Okay.
He has a history of taking other people's property. 2012 Grand Theft Auto, he violated probation. 2011 Grand Theft Auto. 2011 theft. 2008 theft. 2008 possession of cocaine with intent to sell or distribute. 2006 theft. Resisting without violence, loitering or prowling, 01.
Okay, here's what I'm going to do because of the way this probable cause reads. I am going to set the bond at $2,000, but I'm also going to place him on level 2 pretrial release with a monitor. I would allow him to work if he is working, and we'll see him then. Okay, thank you.
No victim contact, Your Honor?
Oh, yes. Mr. Alexander? Mr. Alexander? Mr. Alexander,
Yes.
I'm also ordering no victim contact, okay?
Yes, sir.
Okay, thank you, sir. Nicholas Peraza?
Can I see your document real quick, please?
Come on up. Judge, Mr. Peraza declined to serve as public defender.
Mr. Peraza, you being held on a $100 bond of possession of cannabis less than 20 grams. You're released on your own recognizance on possession of drug paraphernalia. I've reviewed the probable cause affidavit. I find probable cause but you're also being held no bond on 3 separate felonies, and you're scheduled to appear before the court on 4/25 at 8:30 a.m. Thank you, sir. And Thomas Souza?
Your Honor, I was going to be asking that if this case could be reset for 24 hours, if I could proffer to the court. I'm going to be getting photographs from the detective that investigated this matter of the damage to support a finding that the amount of damage is over $1,000.
It's also my understanding Mr. Souza has private counsel.
Correct. He has Mr. Michael Glasser.
Okay, so why don't I reset this for tomorrow morning? That will give the state 24 hours, and it will also give us time to. Who is your Michael Glasser? We'll notify your attorney, Michael Glasser, to be here tomorrow at 8:30. Okay, sir?
And
alrighty. Is there any way that the bond can be posted, at least so I could
well,
talk to my
Kelmo's
attorney
actually a
also?
PBL judge.
Listen, everybody. I can't hear two people at once.
Sorry, Judge.
Okay. Mr. Souza, tell me what you wanted to ask me.
Oh yes, I talked to the detective that was handling the case. He said that I could maybe get a bond so I could get out.
Well, that's
and talk to my family and go back to my job.
Well, that's
at least
what,
for the meantime.
That's what we're going to determine, but we're going to determine that tomorrow when we can get your attorney in here. I can't do anything without your attorney here.
Gotcha.
Also,
if my attorney.
Also, the state has asked for 24 hours with which they're allowed to have pursuant to the statute for further information regarding your case. So I'm going to set it tomorrow at 8:30.
Okay.
All right, sir. Thank you.
The only thing I would ask to avoid confusion, since you're not going to be here tomorrow, could you possibly write in the findings that it's reset for PC determination and not a perfection? Because the last time I asked you to reset a case, it was put on the docket as a perfection.
Okay. Reset for PC determination.
For probable cause, right.
I thought I heard something pop.
All right. Anything else?
Thank you,
Mr.
Judge.
Romero?
I'll see you today at 1 o'clock.
Oh, we'll be here. Thank you.